Lewis County, cause 17-2-615-234. Mr. Eisenberg, you escaped. I had anticipated you being here and looked up and you weren't. Is this matter ready?
Yes, Your Honor.
Yes, sir.
Good morning, Mr. Thomas. Correct. Mr. Thomas?
Yes,
Is that-
Your Honor. Thank you.
And so this matters before the court today regarding a PRA scheduling conference under our local court rule. I saw, Mr. Eisenberg, that the county had attempted to note a motion for judgment on the pleadings, which I believe was over cap, and so it was not set. But the county had set a motion for Civil Rule 11 sanctions, and that was set for March 2nd. But I think you acknowledged in your motion for a judgment on the pleadings that that might not work with whatever dates the court sets as part of the scheduling conference. Is that correct?
Yes, sir. And someone, I guess, beat me to the punch on the dispositive motion calendar. I had made an attempt to check that it was open. It just, I guess someone else probably filed earlier that day after I had checked before I got up to file. But again, I don't have any, I fully expected that because the point of this calendar is to schedule how the case shall proceed, that Your Honor might instruct me or just move it anyway. And so I'm happy to place that where Your Honor thinks is appropriate. In part because it sort of depends on how Your Honor wishes to handle the case. As you can sort of get a sense from the fact that I filed a motion for judgment on the pleadings, there are some legal questions that could potentially resolve the case before we ended up sort of getting into the facts a bit about the full nature of the case. And I've spoken with Mr. Thomas about it. One of those issues, which is nested sort of in the middle of my motion, is whether if an agency receives a request under the Public Records Act and then says essentially, no, this is a Court Rule 31.1 request and responds to it under 31.1, whether that action by law is a denial of the request that could be a violation of the PRA if the agency was mistaken. That is a sort of threshold legal question, it seems, that potentially could resolve the case on narrow grounds before the whole case were considered. And I was not sure if Your Honor wished to set a single merits hearing at which everything was to be addressed, or whether Your Honor wished to have a sort of legal motions hearing earlier than that, and then have a more full-blown, fact-driven merits hearing after. And so I just told Mr. Thomas I would alert the court to that possibility so that you could make your decision about how you'd like the case to proceed.
Thank you, Mr. Eisenberg. Are there any, from the county's perspective, and then I'll turn to Mr. Thomas, are there any other issues that the county perceives regarding this complaint and setting a merits hearing that the county thinks the court should be aware of? And so specifically I'm looking for any discovery issues, or whether there's going to be a need for in-camera review, anything like that.
There is at least one discovery issue. It is mentioned in the motion for sanctions as the second grounds, in that there's a communication sent sort of many months after the request response began that there's one communication that's sent to the address that sent in the request, and then there is a communication with a separate email address which has an anonymous requester about the same communication, and there's a back and forth in which it is clarified at that time. Lewis County says it's producing documents under the Public Records Act. And there is a discovery issue as to whether the requester in this matter, Mr. Cortland, received or would have seen that communication, because depending upon how the court rules on the legal issues, it might be relevant as to whether he had been told that. And so Lewis County would plan to propose some discovery to the other side about Mr. Cortland's access and use of that email address. And who has access to those emails and who uses them, so we could know the answer to that question. Beyond that, I believe Mr. Thomas may have some questions about what documents existed, and so I'll yield to him on that.
And does the county believe there's a need for any in-camera review? It didn't appear that way from the complaint.
I don't believe, from my recollection, that there are, other than the GR 31.1 and whether that counts as a claimed exemption, I don't believe there were other exemptions for which we attempted to not provide records. Do you recall any?
I don't believe there are.
Right. So it doesn't seem like in-camera review would be needed.
Thank you, Mr. Eisberg. Mr. Thomas, and just as just so you all are on the same page as me, the reason that the court sets these merits hearings, we attempt to do them in an expeditious way because they should be resolved quickly when possible. And so that's why the court goes to the effort and why we have a local rule to try to have merits hearings set in a reasonable time frame for the parties. And we try to efficiently get through any unique issues that need to be addressed so the parties can actually get to the merits. And that's the purpose. Now, the issue Mr. Eisenberg brought up about motions the county wants to file or has filed, the merits hearing is the court's responsibility to set that hearing in a way that, again, gives the parties a reasonable time period to have the matter ready to get to the merits of the matter. Parties can file whatever motions that they want to file as long as they're timely and they follow the other civil rules. So the court wouldn't, for example, necessarily get into a situation of moving a motion that the parties or that one of the parties had filed. So, Mr. Thomas, are there any unique issues that you see in this particular public records action?
Your Honor, well, first, I believe that defendant Lewis County and plaintiff Mr. Cortland agreed that some form of an amended complaint will need to be filed. I believe that there are some factual issues that need to be readdressed, and I think Lewis County and Mr. Cortland both agree that there are some factual issues that need to be addressed, and we agree on one or two of them for an amended complaint. And so I think that that's one issue that we would like to deal with relatively quickly in the next week or two and present that to the court. And I think we may be able to do that as a joint motion to amend the complaint. Also, by reading some of the filings by Lewis County, Mr. Cortland is indigent in this case, and I appreciate the court's concern about the expeditious process of Public Records Act cases, and Mr. Cortland shares that concern because he has limited resources. And since under LCR 16(1)(e)(1), we want to identify what issues are relevant today. And we don't think any issues, at least for the merits hearing, we don't think whether there are other requests made by anonymous requesters is relevant to the merits hearing of whether or not there was a denial of Mr. Cortland's request from a separate email address. We believe that there was a claimed exemption under GR 31.1. The Public Records Act states mandatory duties by using the word shall, that agencies shall do, and it also has rigorous search standards laid out in case law, adopted by FOIA case law, that GR 31 doesn't have to do. So we believe, similarly to Mr. Eisenberg was stating before, that there are that the merits hearing probably should be comprised of. I believe that I don't even know if we believe that there are any factual differences at this point. We believe that it's purely a merits hearing may be able to just deal with the issue of whether or not GR 31.1 constitutes a denial under the Public Records Act. asserting GR 31.1 and providing documents under GR 31.1, whether that constitutes a denial under the Public Records Act. And we believe that that's what the threshold issue for the merits hearing should be.
And Mr. Eisenberg, do you agree with that framing of the issue?
I do, although I don't believe that's the only issue. I believe that that one could be dispositive if it were decided that that responding under GR 31.1 instead of the PRA, because it involves the provision of records anyway, does not violate the PRA. That would resolve the claim, I believe. And if it were decided oppositely, that substituting GR 31.1 for the Public Records Act, if it was not appropriate to do so, if that was itself a violation or a denial, that was wrong, that would also, that wouldn't fully resolve the case, because then the question would be what penalty would attend that. But it would fundamentally change the course of the case.
Well, it appeared to the court, and it's why I wanted to hear from both of you, it appeared that the issue is more of a legal issue. It seems like the parties would potentially be able to have an almost shared set of facts. Again, I'm not saying you need to, but based upon the way the issue's been put forth, it seems like one that we could deal with in relatively short order. Well, the amended complaint, obviously, the sooner that's done, the better, just so the parties are able to continue to hone the case so we can get to that merits hearing and resolve any outstanding issues, except for penalties. I will tell you that the court at the merits hearing is just looking to see whether a violation of the Public Records Act occurred. And then if the court makes a finding that there is a violation, then there'd be a separate hearing. That would be a penalty phase hearing.
If I may, Your Honor, I don't want to speak for Lewis County, so if I'm wrong, please correct me. I believe that we both have issues that would need discovery for a penalty hearing. For instance, Mr. Cortland would like to know whether an adequate search was done under GR 31.1 and whether any documents were missed under a GR 31.1 search that would have been provided under a Public Records Act search. And I think that Lewis County would like to know whether or not Mr. Cortland had notice of this request to another email address, which may mitigate the penalties. And so I think that we would both like to address discovery for the penalty stage, but I would agree with the court that I think that we may agree on almost all the facts for the merits hearing.
Very good. Well, let's look at some proposed dates then. It looks like the soonest available merits hearing date the court has would be March 9th at 9 a.m. How does that work for the party's schedule?
That's fine with Lewis County. When I saw that the second had filled up before I filed, I looked at the 9th, and the 9th is fine for me.
That's fine with me too, Your Honor.
Then let's go ahead and set the merits hearing for March 9th of 2018 at 9 a.m. That would then, this will be the briefing schedule, and I'll ask that the parties devise an order capturing these dates, which hopefully you could work together to accomplish today. If not, it can be sent in ex parte or presented if the parties can't reach agreement, but I'm sure you'll be able to. The filing and service of the petitioner's brief would be February 9th. The filing and service of the respondent's brief would be February 26th. And the filing and service of petitioner's reply brief, if any, would be March 5th. And then regarding the amended information, obviously if the parties can reach agreement on that, that's something that if both parties are in agreement on, it's set in with the ex parte process, that can be handled in that manner. You could come in on the 1 o'clock calendar. There are many ways that you can accomplish that. Any other questions, Mr. Thomas, or issues that the court can help clarify?
Yes, there's one lingering issue. I would like to just clarify what the court and Lewis County would like to do with the motion to dismiss at this point, since we have a merits hearing right around the same date as the motion to dismiss.
Well, I'll hear from Mr. Eisenberg on that, but it would seem to the court, based upon the record that's been developed by both of you, that it makes sense to simply have that occur at the merits hearing. But I'll hear from Mr. Eisenberg if he has a different viewpoint.
I agree with Your Honor, except in one respect. And I apologize for getting into the weeds just a tiny bit here. I will try to be brief. If it were the case that the court ruled in Mr. Thomas's favor against Lewis County that that substituting GR 31.1 for the PRA is a violation if it is not supposed to be done, the one other wrinkle in this case is that the Lewis County's response under GR 31.1 continued until a point at which Lewis County represented that it had sort of changed its position based on the passage of time and the receipt of 2 other requests. And therefore it resubmitted material to Mr. Portland, including under this request, and in Lewis County's belief indicating that it was doing so under the PRA. And so there's the one sort of lingering issue is whether you could change horses in midstream if it were, if your response was still open. That sort of raises that same discovery issue that we alluded to earlier about whether Mr. Portland would know that Lewis County was attempting to provide him the records under the PRA in midstream. If we simply rely only on the legal issue, as I previously filed, without doing any of the discovery about the other email address, and we get to the merits hearing, Lewis County might be prejudiced depending upon how the court rules, because of course we don't know how Your Honor will rule. So I ask permission to, as a precaution, to begin the process of finding that out now. Again, I don't believe it's going to be a massive quantity of discovery. It's just going to be a request directed to see who has access to and who uses the emails from the one account that's at issue.
Mr. Thomas.
And we're happy to accommodate those discovery requests. I talked to Mr. Eisenberg out in the hall, and I said whenever he would like to get it to us. I think that's a very pertinent issue, as I said before, for the penalty stage. However, the case law is very clear that once an exemption is cited, that's a denial of the records, whether in whole or in part. And so Mr. Portland argues that that's an issue for the penalty stage. Whether they change the issue in midstream is an issue for the penalty stage. Whether they acted in good faith and whether they decided to adhere to the PRA are issues under the Yusufian standard, not issues for the merits hearing.
Are you objecting to Mr. Eisenberg's request to do that discovery at this point?
No, we are not. We're happy to accommodate that discovery at this point. We are only suggesting that that should not be an issue for the merits hearing. That should be an issue for the penalty.
Well, and I appreciate that, Mr. Thomas. I guess from the court's perspective right now, you both know this case to a far greater degree than the court does. I've reviewed the materials, but I certainly am not in a position where I can predict how the court's going to rule on this issue. And I guess my only thought is I'm hearing from Mr. Eisenberg that basically the county might have a defense in the alternative, and it might not necessarily be that secondary theory might not really be a perfect defense, but it's a sort of a partial defense, if I'm understanding the county correctly. So I don't know how that's all going to play out, but if you're not objecting to that discovery to that degree, it makes sense to me just to have it happen now, and I don't see any downside to that. Okay. So if that can be captured in the order as well, that would be appropriate. Anything else, Mr. Eisenberg?
I have nothing else. Thank you, sir.
Very well. Mr. Thomas, nothing else?
No, Your Honor. Thank you.
Very well. Well, thank you both, and I'll look forward to that order. I don't know if you will be able to present it today. If so, I'll be happy to sign it today. If not, like I said, the ex parte is probably going to be easiest for you.
Okay.
Thank you, sir.
All right, you're welcome.